All right. Welcome to the latest installment of Protecting Your Legacy, one lunch break at a time. My name is James Greenwood. With me today, I have Steph Dr. Steph, excuse me, and Benjamin Young. We are talking about how criminal convictions can affect estate rights. And I'm very excited about this because Steph is our preeminent, criminal attorney. Steph basically does a lot of defense work. In fact, I think you thought you were going to be in a murder trial this week, didn't you?
I did. Yep. But now that'll be November. So here I
Ah,
am.
yeah.
Lucky you.
Very exciting, and I love it. So when we were talking about criminal implications in um, probate or in post-death matters, I think the big thing that really springs to mind is, well, can I murder this person and still get the money? Ben and Steph, what are your thoughts on that? Steph, can I murder you and collect your life insurance? I mean, is that a
I
thing?
mean, it depends, right? Like
It
it's
depends on
only
how.
murder if they can prove it. So really it depends. But I'll let Ben handle
That's
take that
that's fine.
question.
I mean, what you're talking about, James, is the Slayer statute. And what it does say is they're going to act if they can prove that you actually murdered someone, you cannot inherit from their estate. So really what you're looking at there is they're going to act as though you predeceased the person who left you something. So under the terms of their estate plan, they're going to act as though you aren't there anymore, and they're going to move on to the next heirs that are behind you. So that would end up passing, whether that's down to your children or the other beneficiaries. That's what would end up happening if that sort of conviction ever did come down. But my guess is we're probably talking about a few crimes that are less severe than maybe jumping right into murder, if that's the case.
Yeah, and I think that's the thing that that always comes up is, can you commit murder and and basically still get everything? And the answer, I think, and most of the time is going to be no, right? I'm sure there's an exception to everything, but generally, if you actually murder somebody, you're generally not going to get their stuff. And we don't, and that's just a good general rule. I think every state in the union has that rule, but I could be wrong. Maybe somebody doesn't. It's definitely it's definitely something that is an interesting set of problems. And generally, some states have rules that just say, hey, this only applies in a civil context. Other states say that you actually have to be convicted and criminally, which is a pretty high burden. So I think, it's always going to be state specific. Always talk to an attorney and don't murder people. That's something that I can usually unequivocally say is, don't murder somebody. It's just a bad idea.
I
All
assume you've eased the worry of several spouses out there if that's the case. So that's a good thing.
right. And yeah, and I'd like to take a moment to give a shout out to Erie Johnson. Erie is a trust officer with Quad Cities Bank and Trust. He's joined us today. Thank you for joining us, Erie, in the attendee role. Erie is a great guy. If you're ever looking for somebody to be a professional trustee, I've routinely referred people over to him over there, and he's always met and exceeded expectations for all of our clients that we've sent over there. So thank you, Erie, for joining us. Maybe we should have him on this podcast or on our
On this
radio at some point.
show, did you say?
Yeah, I mean, that's kind of what this is, right? This is just a good opportunity to talk to people who are experts in their field. Really, we should probably do like a whole thing on professional trustees, how to pick one, and how to do that. So that's something to consider, back of our minds. All right. So moving on. So we talked about the Slayer statute. That's the first thing that always comes up. Everybody always asks that. It's favorite. But let's talk about the more kind of mundane pieces of this, right? The day-to-day, thing that we see, um, you know, which this stuff is a little more common, right? So let's talk about somebody who has a child. That child's a felon, and it's surprisingly easy to find people who have been convicted of felonies nowadays. And it seems like, they like there's just this really broad set of things that I wouldn't have ever thought of as a felony that get charged and convicted successfully as felonies. So when we're thinking about somebody who's a felon, Steph, how does that impact their right to own things generally? I mean, is there any long-term impact?
To own things?
Yeah, to own broadly,
So
the classes of
yeah,
assets.
so in
but maybe
Georgia,
they
it's not
can't.
going to affect, like the status of being a convicted felon is not going to affect like your ability to own property the way it would in a state like New York, where like civil death is a thing. That's not the case, at least in Georgia. So there's no presumptive inability to like own property, or accounts or anything like that. I mean, it from a practical standpoint, if someone is incarcerated, it's going to be a lot more difficult for them to be managing anything. I don't think the prison tablets have that capability yet. So from a practical standpoint, there's that consideration. But in terms of like just ownership outright, it's not necessarily an issue. The sort of bigger limitation that you run into is someone's ability to serve as an administrator or executor. In Georgia, if someone has had their rights restored, then they do have the ability to serve in that capacity, even if they are a convicted felon. You just might run into some, pushback from the court, but technically, legally, you would be able to if you have had your rights restored. So like your voting rights, things like that.
What happens if there's firearms in the estate? Is that a problem in Georgia?
Yes. So I mean, convicted felons are not allowed to own firearms in the state of Georgia. And so unless there's like a whole separate process where you can like petition to have your gun rights restored. So if that process has happened and those rights have been restored, then you would be okay to inherit like a gun collection. But otherwise, no, like that would be a problem. You can't have any guns inherited or purchased. So
Okay. Yeah, and I think that's definitely a major issue. I think a lot of our clients have firearms. A lot of them have pretty substantial collections actually of firearms.
Mhm.
And even here in Illinois, where firearms are maybe a little bit more regulated than some of the other states where we operate, Iowa and Georgia, which there's not much in the way of regulation in either one of those states. They're both very we'll use the phrase gun-friendly states, firearm-friendly states. Let's talk about, what are the impacts here in Illinois? Ben, I mean, convicted felons, I mean, here in Illinois, they can't own firearms. What happens, and generally, how does that impact kind of the considerations for who you're picking as
can
a
I
administrator or executor here in Illinois? Oh, go ahead.
can I interrupt you for 1 second? So you said cannot own a firearm. To clarify that point, it's they cannot possess a firearm. So if it's in arm's length, they can be charged with a felony of possession of a firearm by a convicted felon. So they can't even like hold the gun collection to like give it to somebody else. Like the guns can't be in arm's reach, or that's a felony in and of itself. So just a point of clarification.
Yeah. Point of clarification in case anybody ever asks. Yeah. And as a reminder, guys, this is intended for educational purposes only. It is not intended as legal advice. You need to consult an attorney, in your local jurisdiction to talk about, well, what are the implications here? We're just all of this is always going to be educational intent only. All right. So Ben, let's talk about Illinois for a second. What about
first of all, there's a two-level part of what you talked about there. One is the gun issue, which again, there's a lot of clients with guns around here. The big thing is it all comes down to the FOID card, right? It's if you are in Illinois inheriting, that's the important part of this, is if you're inheriting a gun, you do have to have a valid FOID card to be able to inherit that gun. If you do not, you will not be able to inherit that gun. So it's very important that, okay, if your beneficiary lives in the state of Iowa, great. They've got to follow the Iowa rules on how they're to be able to inherit a gun. But if the beneficiary lives in Illinois, So even if it's a Georgia trust, but they're leaving their guns to someone in Illinois, they have to have a valid FOID card to be able to inherit that gun. Now, on the flip side, serving as an administrator or an executor. So Illinois does allow a felon to serve as an administrator or an executor as long as it was acknowledged in the will that the person is a felon. Okay. But there's also limitations on that as well, because it comes down to what was the felony for. Okay. If the felon, the big thing you're going to notice is they love to say if it's anything of moral turpitude, right? So they're talking about, did you financially exploit an elderly person? Did you exploit somebody with a disability? Did you have financial identity theft? The big thing they're looking for is, was your felony associated with you lying? That's the bigger issue. If it does involve that, they're going to disqualify you from acting as an executor or an administrator, even if you're named in the document. So again, there's a whole spectrum of felonies out there, but if it has something to do very specifically with the job title of administrator or executor, most likely the judge is going to disqualify that person. But if they do have a felony that's not going to affect them acting as the administrator or executor, it has to be acknowledged in the will. If it is not, it's going to get them disqualified as the administrator, as the administrator or executor.
Okay. And I think we've talked about this before, kind of the purpose of probate is twofold. It's not just to get the assets down to the kids, it's also to make sure those creditors get paid. And there's a tension in the probate code that gets addressed. And so that's why those felony convictions are such a big deal. I mean, it's a fiduciary role. It creates obligations to handle the assets within the boundaries as laid out in the code, and follow the law. And there's a presumption in law that assumes that a felon is inherently unreliable. And whether or not that's right is the subject of a whole lot of debate, but it is what it is. And so we deal with the things as they are. So
one other thing to add to that is that's not just the administrator or executor role. When it comes to estate planning, I mean, you're also now talking about guardianship roles. You're talking about power of attorney agents, anybody that's potentially going to be making decisions on your behalf. If they've been convicted of a felony that has to do, I mean, the way I look at it is if it has to do with honesty, that's your big kind of red flag that person's not going to be able to do that. So it's really important to make sure who you named is somebody that is qualified to act in that position.
Yeah, absolutely. And let's turn for a second to these guardianship roles. And we routinely do appointments or requests for an appointment of a guardian, right? And that's one of the things that I do want to emphasize here. You'll see, hey, who do you want to be managing your children, both personally, so who's supposed to take care of them, and the estate. It's a question that comes up all the time in our intake process as we talk to our clients. Maybe you have a disabled child who needs somebody to manage their affairs over the long term. Or maybe you've got an aging parent, an elderly parent who you are going to have to make provision for. And in those cases, there's a different class of crimes that can really be problematic and challenging. And everybody, I think, kind of understands, hey, these crimes involving honesty or the ability to be honest with the court, those are definitely going to impact, but there might be lesser things that could impact that. Steph, I'm going to turn to you for just a second here. Can you talk a little bit, just a little bit about, I think they call it, is it DFCS in Georgia? And
DCFS.
And potential, yeah. And here in Illinois, we also have we have some elderly abuse investigations that can happen, and how those might impact a court's determination about who should be providing care for either a child or elderly adult. Can you talk just a little bit about that? and kind of that process.
Yeah, I mean, so like in Georgia, like certain degrees of elder abuse are like a felony charge, but I think it's very safe to assume that if one was to be charged, even charged, honestly, or certainly convicted of either elder abuse, child cruelty, like the court is not going to look favorably on that in terms of appointing them to any sort of guardian or executor or agent role.
Okay, and in Illinois, let me ask some more questions. In Illinois, we have an administrative process that can impact those decisions by a court. Is there any sort of is that an administrative process in Georgia, or is that a criminal process that they?
No, it's an administrative process.
Okay, so a conviction here could be even a lower burden than like a criminal conviction. They could make a finding administratively, and that can have a impact that prevents somebody from acting. Is that an accurate statement?
Yeah, I mean, because oftentimes DCFS is involved in like an investigative capacity, and they're involved in creating like safety plans and things like that. And so once they're involved, like it's I guess like a lower threshold, if you will. So yeah, no, I think any sort of DCFS involvement is like no good.
Yeah, and that's one of the things that I'm gonna it's a hill I will die on. Every time DCFS gets involved with anything, the very first phone call should be to your lawyer, right? And that's just a side note for everybody watching. If you ever see DCFS come knocking on anybody's door, that the answer is call the lawyer.
And one thing to add in that too is with DCFS, I mean, everybody kind of has a bad taste in their mouth when they think of it immediately. Okay, if DCFS is coming to take my kids, the first thing you have in your mind is this is a giant nightmare, right? But I mean, from the other perspective of it is if you're gone and somebody's going to become the guardian of your kids, I mean, the whole idea of this is for the court to be watching out on the benefit of the kids, right?
Mm-hmm.
Or a disabled adult or whatever that might be. And really what they're doing is they're trying to make sure that they're naming somebody who's actually going to do their job. So, I mean, I know we immediately kind of have that, our gut says this is a bad feeling. We don't like this. But really what they're doing is, if you pass away with no will and you don't name guardians for your kids, but you have 3 siblings and one of them is hypothetically, the one person in your family you would never want to take care of your kids, but they're the ones that show up to court in a nice suit and they're ready to say, hey, I should be the guardian. This is really the court's chance to stop that from happening. So it's not all a bad thing.
That's a fair point. Yeah,
but at the same time, I know it's a major annoyance for people when they're planning their estates, but at the same time, the whole purpose of this procedure is to protect the person that's being taken care of. So it's just something to keep in the back of your mind.
Yeah, absolutely. And so when you've got kids who are underage, you've got adults, and that's the other thing that we always like to emphasize to people. Any sort of criminal conviction, it doesn't matter, a felony, misdemeanor, what have you. It could even be an administrative conviction. Those things can impact the court substantially. And the reason is because anytime you're dealing with somebody who's disabled or incapacitated, the court is always going to take a look at best interests. And that is the lodestar for at least the courts in Illinois, the courts in Iowa. Steph, is that the measuring stick that they use down in Georgia, best interests of the disabled person?
Mm-hmm.
Yeah,
absolutely.
And so that's the thing to just keep in mind is we can put whatever we want in our documents, but at the end of the day, if there's a disabled person, the courts are going to take a look at that, and they don't give a hoot about anything else. They're like, what is the best interest of this disabled person? And they're going to follow that road to its logical conclusion. So there's that. Okay, so I think we've worked through that. So we've talked about, so let's just do a quick recap here. We talked about criminal convictions and the executorship. We've talked about potential impacts on guardianships, the ability to hold firearms. Those are major items that we get asked all the time. Are there any other criminal interplays that you can think of, Ben, here that we should also be addressing that we haven't addressed yet.
Yeah, so one thing, I mean, to consider too would be just seizure or forfeiture of assets if a person who has been criminally convicted now all of a sudden inherits. So all of a sudden, mom and dad might be saying, okay, I've got 4 kids and I want everything to go 4 ways. But let's say Johnny has a conviction that now he owes the court restitution. If all of a sudden he inherits, that money's going to go to pay for whatever bills he owed, as opposed to that actually getting, protected for him or something along those lines. Now, again, there's ways to protect it within your estate plan, but if you just say he gets it outright, whatever bills he has out there, whether those are court fees or whatever the criminal penalties or whatever it might be,
Restitution.
yeah, I mean, that could just disappear.
Yeah. And Steph, can you talk a little bit about restitution and maybe court penalties, court fees? What do we typically see in the criminal process? I know I've seen a few states that do, like, even if you have a public defender, you have to basically end up paying for that public defender.
Yeah, I mean, in Georgia, it's on a county by county basis whether the defendant ends up actually paying for public defender services. It varies a little from county to county, but in terms of restitution, it really depends on like what kind of crimes we're talking about. If it's like a property crime, you're 99% of the time going to be required to like make the person whole and pay for whatever the damage was. If it's like a sort of violent crime or something like that, it just depends on like if the judge imposes restitution. Oftentimes there will be, and yeah, I think that's a great point because that's not something that I often think about, but I think yeah, in terms of like assets being ending up not where people intended them to if their estate plan isn't considering the sort of conviction. So I think that's a really smart point.
Okay. And I think one of the other things that, when we're thinking about a criminal conviction, even if there isn't a conviction yet, I know that a lot of times you're working with folks who are out on bond, and let's say that somebody's going all of a sudden inherits a ton of money. Is that going to impact the bond consideration as well? If they could it impact their ability to travel or something like that, and maybe a judge might consider their assets as part of that risk?
I mean, it certainly has a bigger impact on people who have been determined indigent by the court and are having their representation paid for. Like the court's not just looking at like your earned income, they're looking at all of your assets as a whole. So if you inherit like a chunk of anything, that could disqualify you from representation by the public defender's office. That's like the first thing that comes to mind. But yeah, I mean, I think like if you had I don't know that a judge would like change your bond if you've already been out and haven't violated your bond conditions, but like if you had used property as collateral and the person who owned that property died and now that they want to sell the house, like that's going to be a problem for sure. They're not going to be able to if there's property was used as collateral on a bond. So yeah.
Okay. And we had talked about sureties in an earlier episode here. And for those of you who maybe didn't attend that one or weren't able to catch up on that, can you talk about sureties a little bit and what those are, and then kind of how a criminal conviction might impact the ability to act as surety?
Yeah, what a surety does is they kind of act as an insurer over the estate. So typically, what would happen is somebody applies to be the administrator of an estate. And one of the things the court is potentially worried about is that administrator is going to take all the money from the estate. They're going to pick up, move, and flee the country. And now all of a sudden, there's a bunch of bills out there that need to be paid. And, these were valid creditor claims and things along those lines. And what the surety does is they fill in for that administrator if they were to turn and run off like that. So they would be responsible for covering those bills. What a surety typically has to do is fill out a brief financial statement with the court that says, in essence, first of all, they're good for the money if the person did ever end up doing that. But one of the questions on there is going to be, have you been convicted of any felonies that potentially could affect you serving as a surety? So the judge is going to look at this person. And again, if we've got some sort of crime of moral turpitude that says this person is a regular, liar or something along those lines, the judge is just going to look at that financial statement and say, I don't know why I would trust this. I'm not going to allow this person to be a surety over this. So it's a major thing that would be considered by a judge as to whether or not they would approve that person as a surety.
Absolutely. All right. All right. So we're almost out of time today. Any last words? Well, Ben, we'll have you go first, and then Steph. We'll have you go right after Ben to see if you have anything additional to provide. Ben, any last words here for the
I
folks
think
listening?
the big thing from an estate planning perspective is just if you do have somebody in your family that does end up getting convicted or even accused of it, it's something you want to sit down and discuss what your actual plan is. I have some clients that maybe want to disinherit that person. I have others that just want to protect it, that once they eventually serve their time, get out, whatever it might be, they have assets there for them that they're still able to inherit. So just make sure you have a chance to sit down with your attorney and plan if something like this does happen.
Excellent. Steph, any thoughts as we get ready to part ways here?
I feel like we covered it.
All right. Well, so today we just covered a little bit of information about criminal impacts on that estate process, including potentially who you can name as your administrator or executor, who could be the administrator or the executor, who can act as the caretaker for your adult parents, adult child or children, or your minor children. We've talked a little bit about the impacts on firearm ownership. We talked a little bit about who can act as sureties and how the criminal conviction might impact that. My name is James Greenwood. I'm an attorney licensed in Illinois and Iowa. I'm responsible for this. Other attorneys on with me today are Benjamin Young. He's also an attorney licensed in Illinois and Iowa, and Steph Iasiello, who is licensed in Georgia. Steph, and I apologize in advance for butchering your name on the previous shows.
It's okay.
Your
Every
partner
time.
here, I don't know why, just did that,
One
but
of
it
these
is
days
what
you'll
it is.
get it.
If you have questions or concerns about today's the topics we covered today, or just want to get in touch with us, we can be reached at 855-528-6022. Again, that's 855-528-6022. Thank you so much for joining us today. We wish you a great day and a great week. Goodbye.